Nicolette Levy, QC, and Annabel Markham, criminal lawyer, and they're going to be here by video. The title of their contribution is The Implications of the Conversion Practices Prohibition Act 2022 for Counsellors, Teachers and Parents. Nicolette Levy is a Queen's Counsel with over 30 years' experience in all types of litigation. She was counsel for Speak Up for Women in Whitmore versus Palmerston North City Council. Annabel Markham has over 25 years' experience as a criminal lawyer. She's a specialist appellate advocate and joined the independent bar last year after 20 years at the Crown Law Office, where she was a senior Crown Counsel. Annabel and Nicolette will be speaking to us by video.
Thank you very much for that introduction. I think that was Christine who did it, but we couldn't see you, so we can't be too sure. I think, as you said, we are both Nicolette and myself, Annabel, we're both barristers practicing in Wellington. My background is with the Crown until recently, whereas Nicolette in the criminal sphere has been from the defence side of things. So we've had numerous appeals on opposite sides over the years. I think Nicolette would like to think she's won most of those.
More.
So it's quite nice to actually sit next to her for a change. So look, we have prepared a handout for audience members. So hopefully that has been made available both online and in person. And like typical lawyers, we started off with a disclaimer. And I mean, it really shouldn't be necessary to say this, but there has been an awful lot of misinformation on social media. And so I want to make it perfectly clear that, and I think I'm speaking for Nicolette too, that we're not here to support conversion therapy. We're not here to suggest in any way that there is anything wrong or defective with gay, lesbian, trans or bisexual or gender diverse people. Quite the reverse. And you know, we both have members of our close whānau in that category. So we're here really as lawyers to talk about the scope of the legislation, because some of the provisions are quite broadly worded. And I think a particular area of concern that's been identified to us is the issue of a potential impact on cautious or exploratory therapy. And in dealing with gender incongruence and dysphoria in the child and adolescent patient population. And so a concern that the Act might impact on those areas of therapeutic practice. It isn't just some sort of bogeyman that's been invented. It's actually the very reason why gender identity was removed from the conversion therapy ban or proposed ban in the United Kingdom. And I think anyone with any familiarity with the sort of highly politicised rhetoric in the space will appreciate that it is absolutely a tactic on the part of some people who promote the affirmative only pathway to seek to sort of stigmatise any of the alternative approaches as constituting a conversion therapy. And it's been a hugely effective tactic, because obviously it's quite an inflammatory accusation to make, and it engenders a lot of fear, and it silences people. And I think Stella O'Malley earlier this morning, her discussion made it clear, and likewise the interim report from Hilary Cass makes it clear that there is no consensus professionally about the proper approach to treatment in this area. It's a very fraught area, obviously, and there has been this discernible shift, at least in overseas jurisdictions, away from the affirmation only and towards more exploratory therapeutic approaches. So obviously, as lawyers, we're not here to talk about the rights and wrongs of the various clinical approaches. I think part of the purpose of our presentation, though, is to hopefully provide a degree of reassurance to therapists and to parents and teachers and other people who are concerned about the impact of the bill. I think our message would be that sort of Twitter discussions and Twitter accusations are very far removed from the realities of a proper legal analysis, and certainly far removed from what would happen in a courtroom in the cold light of day. So I want to thank, we would like to thank the organisers for this opportunity. Certainly reading the interim CAS report, a message that came through very clearly was the view that the lack of open and respectful discussion in this space has really impeded the development of proper treatment for this very vulnerable patient population. So discussion is very important, and we thank you for that opportunity. In terms of what we're going to talk about, dividing it up was a wee bit tricky. So Nicolette has got the important stuff and the more interesting stuff, and certainly more practical aspects of the topic. She's going to be talking about the nuts and bolts of the legislation and how I suppose it may or may not apply in particular fact scenarios that have been suggested to us as possibly of relevance to the audience. I'm going to give a general sort of overview and make some random comments, and then we will both be available, obviously, for the question and answer session to follow. So in terms of the general overview, the Act is... we'll talk about it. I think Nicolette's being a bit shy now. You can talk with. Thanks. Look, yeah, in terms of the background to the Act, it's an interesting Act from a criminal lawyer's perspective, because ordinarily when you'd have a novel piece of legislation, as this one very much is, it would have as its genesis either a Ministry of Justice project or a Law Commission project or something of that nature that would enable the issues to be carefully examined and consulted on. And that process would also enable the proposed offence provision to be analysed within the criminal law framework. But none of that happened in this case. I think, as most people will know, the background to the bill is that it was essentially driven by activists within both the Young Greens and Young Labour factions, and I think also supported by the Young Nats. And there were various petitions circulating around 2018, 2019, some of which were specific to sexual orientation and others not. And that led to a Labour manifesto pledge in 2020 to ban conversion therapy, and there wasn't much detail offered in the manifesto about what that entailed. Then we had the bill that was pushed through Parliament very, very quickly. I think the government made a commitment that turned out to be slightly optimistic, that it would pass the legislation by the end of 2021. Now that deadline wasn't met, but it nonetheless was pushed through very quickly. And the government justified that haste on the basis of what it described as increasing public demand to ban conversion therapy as soon as possible. So a real sort of sense of urgency was talked about. And yet what we see in the regulatory impact statement and the policy documents surrounding the Act sort of these plaintive complaints from various officials that they simply hadn't had the time and didn't have the data that would give them a proper understanding of the issue and the extent of it. And there's recognition that from a quality assurance perspective that the legislation was a wee bit lacking, and an acknowledgement that a more extensive consultation at the outset might have assisted in the process. But of course, once it reached the select committee stage, there was very extensive consultation. So I think a consequence of this very rushed and slightly kind of unorthodox background to the bill has posed some issues with the bill itself. One thing that I would say is that the discussion of the medical and social scientific literature on conversion therapy is very once over lightly in the policy documents, and there is an assumption on the part of officials that the literature on conversion therapy for sexual orientation in the adult population can be just simply generalised and applied to gender identity in children and adolescents, whereas I think that is highly debatable. And something that struck me particularly was an assumption or an assertion really that's built into policy documents, and I think it also finds its way into the Human Rights Commission website, and that is this notion that there is robust and scientific evidence that you can't change gender identity. Now, you know, I'm not obviously an expert in this field, but I understand that is certainly highly debatable as well. And the CAS report, or the interim report, identifies the question whether gender identity is properly to be regarded as fixed or close to being fixed, or whether it's more fluid, is one of the sort of flashpoints, if you like, in the wider debates. So it's led to some criminal offence provisions that are quite anomalous when you compare these offence provisions to other offence provisions on the statute books. Nicolette's going to be talking about the nuts and bolts of that. But therapy, talking therapies, religious practices, parental discussions, parental decision making are not, you know, typically the subject of the criminal law. And as the Crown Law advice on the bill recognises, there are significant limitations on fundamental rights and freedoms of others, and particularly freedom of expression, and to a lesser extent, Crown Law said, manifestation of religious beliefs as well. The under 18s offence provision, and again Nicolette will be talking about this in more detail, but the provision that deals with conversion practices in relation to young people is a particularly unusual offence, because it applies in circumstances where no harm has been caused or even risked on the facts, and where no harm has been intended, and yet it carries a relatively significant maximum penalty. There's also no defence of consent, which is itself anomalous. This might surprise the audience slightly, but even very serious violent offences under the Crimes Act have a presumptive defence of consent that applies, and that's because the criminal law gives a premium is placed on individual autonomy in the criminal law, and yet consent has been essentially taken out of the equation here. Some of the key terms and slightly contentious terms, so gender identity, gender expression, they're completely undefined under the Act. And when this was an issue that was identified in a number of submissions on sort of both sides of the fence, and the government said an interesting thing in response. It said, well, look, we think that it's important to define these terms, but we're going to do that work in the context of our review of the Human Rights Act, not at this point in time, which, you know, on one view is a strange priority that definitions are seen as important for human rights legislation, but not for criminal offence provisions that you know, give rise to the possible penalty of up to 5 years jail. So I think essentially, and this is really just my take, and it's reading between the lines, I think the government has pushed this act through for reasons of political expediency, and there are some, you know, protections built into the act that Nicolette will talk about, but ultimately I think the government has left it to the prosecution process and to the courts to resolve the sort of difficult issues that will arise in some of the more marginal cases, if you like. So I wanted to talk briefly about the prosecution process, because there are some important protections that have been built in to that process. The first is the decision to prosecute in the first place, which will be made by police in the first instance. Now, there's a sort of a misconception that if there's a complaint made to police and it's got evidence to support it, that a prosecution automatically follows. That's certainly not the case. There's a discretion involved. That discretion will be guided by the prosecution guidelines, which are available online from the Crown Law Office website. Essentially, there's two components to that discretion. You look at the evidence and whether it's sufficient to give rise to a reasonable prospect for conviction, bearing in mind the high standard of proof required in criminal cases. But secondly, there's a public interest dimension. So even if the evidence is strong, it might not be in the public interest to pursue a particular prosecution, and that could be for various reasons, including the seriousness of the offence and other factors that I've talked about in the handout. But possibly the more important protection, I think, in this context is the requirement of the Attorney General's consent before a prosecution can be commenced. And actually, contrary to the Select Committee's understanding, it will be the Solicitor General, not the Attorney General, who exercises this function in practice, and that's because the Attorney General is a political person, is in Parliament, and you need to be seen to keep the prosecution process and the criminal justice system free from political influence. So it'll be the Solicitor General that exercises that function. And it's certainly not a standard thing. Not all offences require the Solicitor General, Attorney General's consent. Where there is a consent requirement, it's generally a signal that the particular legislation gives rise to wider policy or human rights considerations that don't, you know, crop up in the ordinary run of cases. And I think where a prosecution potentially infringes someone's freedom of expression, as these provisions do, the Solicitor General will need to make a decision that a prosecution is a proportionate response to the nature of the harm in the given case. And I think also important in this context, because we are dealing with quite broadly worded offence provisions, one of the functions of the consent requirement will be to ensure that prosecutions focus on only those cases that are truly intended to fall within the ambit of the legislation. It's not intended for the marginal, debatable cases. It's intended for the more high-level and serious examples. So I've cited in the handout, by way of illustration, the racial disharmony offence provision, which I think similarly has an obvious freedom of expression limitation aspect to it. And it's interesting that in the 50 years since that offence has been on the statute books, there's been only one consent given, and that was in 1979. Now, I'm not suggesting that the same, you know, ratio of success is going to apply in this context necessarily, but it does illustrate that careful scrutiny will be given to any proposed prosecution. Even if the case does get through these filters of the discretion to prosecute and the attorney's consent function, and it gets to court, my view is that the courts are likely to be very hostile to attempts to apply the offence provisions outside, the very serious cases that more obviously fall within what we might understand to be conversion practices. And I've collected a number of quotes from government MPs during the course of the parliamentary debates, and I've set them out in the handout to illustrate what the government was suggesting is really intended by this legislation. And they talk variously about requiring a high threshold. They talk about conduct that has as a predetermined outcome the desire to change someone. It talks about encouraging people to think that there's something defective about themselves, using shame and coercion. And interestingly, and I think quite significantly in this context, some of the opposition members of Parliament proposed a specific amendment to the bill that would have exempted parental discussions. And the government's response, it rejected that proposal, but not on the basis that the proposal was wrong, but because the government said it was unnecessary, because in the government's view, that simply wasn't the focus of the legislation. So I think, and the other important point to note in that context is that there's no suggestion in any of the parliamentary materials that I've looked at that it was ever intended that the Act should weigh in on the sorts of debates that have been talked about today around proper treatment approaches for children and young people with gender dysphoria. So I hope that does give some reassurance to members of the audience. And I'll hand over to Nicolette, who's going to talk more about the detail. Thank you.
Kia ora. You've all seen me today earlier in a photograph wearing a short dress because I'm Suzanne's sister. I'm going to try and share a screen with you. I've been having one or two difficulties, but hopefully they have resolved themselves while Annabel's been speaking. So now I hope you're all looking at a slide which is a picture of the Conversion Practices Prohibition Legislation Act 2022. That's what an act looks like when it's published. And so it's what this one looks like. I'm going to take you through the sections that will matter as the Act beds in and things happen in respect of it. Just before I do that, I just want to build a little bit on what Annabel said about how this is all going to pan out. There will certainly be complaints about behaviour that is said to breach this Act, possibly lots of them, given the political climate, given the strength of feeling that people who believe in gender ideology have. And there may be charges resulting from some of those complaints. There might be some convictions, but my prediction is there will certainly be acquittals. People will be charged and the courts will say, no, that's not what this legislation is designed to do. And it's at that stage that I think the counselling and teaching community will get feel the relief that I'm going to encourage you to begin to feel today. I'm going to try and encourage you to have some confidence that this Act is not going to change your lives. It's not going to criminalise your everyday professional practices. But that will take a little bit of time. The system will take the time to make that apparent. That's my prediction. My second slide, which is Section 3 of the Act, and it says, and I'll read it to you. The purpose of this Act is to recognise and prevent harm caused by conversion practices and promote respectful and open discussions regarding sexuality and gender. And obviously that's my comment what's not to like. Because despite the way in which this Act has been applauded by some camps, in my view, that 3B is important, and you should not be shy to say, I've read that, and I know that one of the purposes of it is to promote respectful and open discussions regarding sexuality and gender. So, person who's telling me I have to affirm and I can't wait or treat a client the way I would normally do so, just think about that 3B and let's have a respectful and open discussion about it. So Section 5 of the Act is about the meaning of conversion practice, because that obviously is essential to the Act. And it says that a conversion practice means any practice, sustained effort or treatment that is directed towards an individual because of the individual's sexual orientation, gender identity or gender expression, and is done with the intention of changing or suppressing the individual's sexual orientation, gender identity or gender expression. So what my slides that you can't see very helpfully do is break down those concepts. The first concept is any practice, sustained effort or treatment. Now, in my view, that is going to be interpreted as this Act goes along as a course or a pattern of behaviour being a person who a complaint is made about. So it's probably not going to be a one-off event or a comment. It's going to be somebody choosing a technique or a strategy to use in respect of a particular client, and it's going to have been chosen from a known range of choices. So somebody is going to have made a conscious decision to apply this practice, effort or treatment to this client or student in front of them. Now, arguably, it does cover a parental defiance of the child's wishes. So if your child or adolescent says to you, you are to call me by these pronouns and this name, and your attitude is no, I won't. I don't want you to be that person. I don't believe you are. I want you to change back, and I'm going to deal with that by calling you by the name I gave you and the pronouns that apply to your sex. So that might be covered at this stage. Whether it gets to the next stage is a different issue. So the next part of the definition is that what is done has to be directed towards an individual, so a person, not a group, because of their sexual orientation, gender identity, or gender expression. Now, the gender phrases, gender identity and gender expression, are not defined, as Annabel has said. The court is, in my view, going to be quite strict about them having to have a meaning that is easily understood and apparent to the person doing the counselling or the therapy or being the teacher or the parent. You can't direct something towards an individual because of their gender identity if it's not there to be seen or explained to you in clear language exactly what it is that you're dealing with. And I think the same would apply to gender expression. It's got to be definable. Now, the next part of the definition of conversion practice is that you have to have an intention of changing or suppressing the person's sexual orientation, gender identity, or gender expression. So this is where the Act really bites. You, as the person charged under the Act, if that's who you are, need to mean to change or suppress the orientation, identity, or expression. It's got to be what you've got in mind as your purpose, to make that change or cause that suppression. So what the number one question that came up when I asked Christine to circulate some questions that people might have that they might like to ask today, the number one question was, do we have to affirm And the answer to that is no. There is no obligation to affirm. The obligation is not to act with an intent to change or suppress. But in my view, there is a lot of space between an intention to change or support and an obligation to affirm. And it's in that space that you can explore with the client or the student or the child. Be curious. Use your normal professional tools of talking to people to explore the issues that are going on for them. And I've highlighted it on the slide, so I feel I should repeat it. You don't have an obligation under this Act to affirm anybody's gender identity or gender expression. Now, the Act deals with what is not conversion therapy. And the first thing that is not conversion therapy is any action that a health practitioner takes when providing a health service if the health practitioner considers in their reasonable professional judgment it's appropriate to take that action, and if they comply with all legal, professional and ethical standards when taking the action. Now, it's a little bit of a technical point as to whether counsellors are health professionals for the purpose of this section. But my advice is that counsellors acting like health professionals, exercising reasonable professional judgment, complying with the legal, professional and ethical standards that apply to them, counsellors acting like health practitioners are going to be treated like them. The courts are not going to say, yeah, well, sure, you considered your reasonable professional judgment, and yeah, all right, you did comply with your legal, professional and ethical standards, but you're not a health practitioner, so we'll get you. That's not going to happen. The focus of this part of the Act and this definition is on protecting practitioners who act professionally and responsibly. So whether or not you are one technically within the Act, acting like one is going to give you that protection. So I have a slide which says counsellors should, and the first is what I just said, exercise reasonable professional judgment in regard to ethical obligations. Consider each case separately is my second point. In your fields, just as in our fields, no two cases are exactly the same. And it's an important part of exercising professional judgment that you recognise that and make separate decisions for each person or each situation that you're faced with. Now, my third bullet point is to document what you're doing and your reasons for it in each case. So if a person wants you to affirm their gender expression and you choose to steer them towards a different form of therapy, write it down. What was asked, what your decision was, why you made that decision, and what you did. And then my fourth bullet point is what I've already said, act like a health professional and the courts are likely to treat you like one. Now, the Act, in a friendly sort of a way, also has a list of what is not conversion therapy. And in my view, most of what they've put on this list is obviously not conversion therapy, and nobody could think that it was, but I'll tell you the list anyway. Assisting an individual who is undergoing or considering undergoing a gender transition. Assisting an individual to express their gender identity. Providing acceptance, support or understanding of an individual. Now that is something that the watchful waiting type of therapy or professional approach could well involve, providing support and understanding for an individual. And then the fourth bullet point under what is not conversion therapy is facilitating an individual's coping skills development or identity exploration, or facilitating social support for the individual. And again, I would have thought that that was well within what counsellors and teachers not wanting to affirm would nevertheless do on an everyday basis. Now, it's not on the slides, but you don't know that, but just so you don't miss it, something I haven't put in the paper is that it is likely to be important as counsellors and teachers that you are available to be consulted for advice or therapy by everybody. You can't set yourself up as a counsellor or a teacher who is not available to support or try to assist a student or a client with a gender identity issue or a gender expression issue. What you are able to offer to those people and the sorts of counselling that in your professional judgment is appropriate is a different issue, but you can't have a blanket exclusion. Can't say, no, I don't see people with those sorts of problems. You have a discussion with them, you explain when you've heard the sort of counselling or support that they want, you explain what your professional approach to that issue would be, so they can decide whether you're going to be a good fit for them as a counsellor. But you can't say, your sort of problem is one I don't deal with. And you'll be aware of the ethical reasons for not being able to discriminate in that way, and there are probably legal reasons as well why you've got to be careful about that. Now, after telling us what is not conversion therapy, the Act then tells us what is conversion therapy. And it gives us these examples. And I promise you, you're not going to see yourselves, I expect, in what I'm about to read out. Conversion therapy is using shame or coercion, intending to give an individual an aversion to same-sex attractions, or to encourage gender-conforming behaviour. Encouraging an individual to believe that their sexual orientation, gender identity, or gender expression needs changing because it is a defect or a disorder. Carrying out a prayer-based practice, a deliverance practice, or an exorcism, intending to change or suppress an individual's sexual orientation, gender identity, or gender expression. So those things are just on different sides of the planet to the type of professional options that I understand available in the form of things like watchful waiting, exploratory therapy, and other alternatives to affirmation. And in my view, the significance of those examples being in the Act is that the courts are going to say, this Act is concerned with seriously bad stuff. Any treatment or counselling done in a professional way, choosing one method of treatment that is preferred by some professionals over another method of treatment preferred by other professionals, is not going to be found to be conversion therapy. So there are two offences in the Act. The first is performing a conversion practice on a person under 18 or someone lacking wholly or partly the capacity to understand the nature and to foresee the consequences of decisions in respect of matters relating to their health or welfare. So that's going to be a person with a significant disability. And it would be obvious if you were seeing someone with those sorts of, if you met that sort of definition. It doesn't have to be harm caused or intended for that offence to have been committed. It's enough that the conversion practice has occurred on a person under 18, even if they wanted it. The second offence is performing a conversion practice that causes serious harm to a person, adult or child, knowing that performing the conversion practice would cause such harm, or being reckless as to whether it would. So, serious harm is defined as any physical, psychological, or emotional harm that seriously affects the health, safety, or welfare of the person. Now, fortunately, this is an objective test. It has to be the view of the court that this level of harm has been reached. It's not the view of the person making the complaint or having a complaint made on their behalf. It's not their view. It's the view of the court that there's been this serious level of harm. And the second significant point about that is that you have to know, to be convicted of this offence, you have to know when you do it that you are going to cause that harm, or you don't care whether you're going to cause that harm. So it's not something you can do by accident. The next slide, which you can't see, is about civil liability. And this is a section which has been put into the Human Rights Act that says it's unlawful for any person to perform a conversion practice on any other person or to arrange for that to happen. And conversion practice has the same meaning as in the Act that I've been not showing you slides about. Now, just like there will be complaints under the Act made to police suggesting that there's been criminal behaviour by people not affirming in this area, there will be complaints under the Human Rights Act. The way that works is the complaints are made to the Human Rights Commission, who invite a response from the person complained about. My advice, if you find yourself in that situation, is to see a lawyer about forming your response to the complaint that's been made, because there are some things that it can be best to say early, some things it's best not to say at all. Ideally, the response will be, yes, I saw X. The problem that X presented with was this. I applied my professional judgment, and the available options for treatment were A and B, and the reason I chose B is because, and you'll have your reasons there. So if you see a lawyer, you're going to get that put into your defence, if you like, early on in the most persuasive way. The next thing that happens is the Human Rights Commission will try to organise a mediation, which nobody has to attend. But if you both want to, the person complaining and the person complained about, you can attend a mediation. That will be suitable for some cases, but not for all cases. If there isn't a resolution at mediation, then the person complaining can take the matter to the Human Rights Review Tribunal. Sometimes the Director of Human Rights Proceedings will provide a lawyer to do that. Sometimes they won't. It's a very lengthy process getting to a hearing in that tribunal. There are delays, unfortunately, for years. And when you get there, and I hope you don't, but if you do, when you get there, the result will be very similar to what I've described in respect of the criminal offences. The court's tribunal is going to be concerned with serious, deliberate behaviour, intending or being reckless as to serious harm. It's my prediction of the way that it will come out when it gets to the courts. So what can you do? You can watchfully wait while keeping up to date with developments in research and policies. Share the articles that you're relying on. I suggest that if there's particular literature or online material that you find helpful as a professional in informing your views about how to deal with situations, then have printouts of those in your office so that you don't have to try to explain it all yourself if somebody challenges your approach. So this is the sort of thing that's informing the way I'm thinking about this issue at the moment. And if you have it available in a handout, a hard copy handout, people might not read it, but at least they're not going to click on the advertisement beside it. Now, what else can you do? You can share gender critical beliefs if it's ethically appropriate. And the reason I say if it's ethically appropriate is because as a counsellor, obviously there are limits on the extent to which you can impose your own beliefs or even share your own beliefs with clients. But if you're asked about your views on affirmation and your views are more gender critical and tending towards an option like watchful waiting or some other approach, you can say that. You can do what you're doing now and support your clients in their decision making using your professional skills. You don't have to affirm them. So my final slide is very encouraging. It says, go forward. Counsel, teach and parent, knowing that you're not required by this Act to affirm gender identities. The law protects gender critical beliefs, and this Act does not prevent your expression of them in most circumstances. Be clear and upfront about your professional views on treatment of gender dysphoria or children and adolescents claiming gender identities. Keep up with research and developments so you have the most up-to-date material to share and offer to share. So if we go right back to the first slide that you didn't see, promote respectful and open discussions regarding sexuality and gender. What's not to like? So we are now open for questions, and I see we've got 3 minutes to hear.
Any questions? There was a question that was handed in the last session, which may be of interest to this. With the conversion practices legislation now in place in New Zealand, could a detransitioner sue a gender clinic under this law?
Yeah, we discussed this, and I think the short answer is no. Yeah, that was actually something that the Select Committee expressly considered and rejected, but also, you know, you'd have difficulty meeting the requirements of the offence in terms of a practice that's designed to change someone's identity and so on. So, yeah, I don't think that that's really feasible. I don't know whether you have a different view.
I didn't catch the question.
It's around the detransitioner wanting to sue for conversion therapy.
Not under this Act.
Yes.
Yeah, that's not what this Act is designed for. I think the complaints in that area are more likely to come to be about professionals promoting affirmation without giving proper consideration to whether other options might be more appropriate for some clients. I think that the detransitioner issue in New Zealand is going to be played out in front of health practitioner complaints assessment committees and what's it called these days, the Health Practitioners Tribunal. That's where these things are going to end up. Not in respect of counsellors, but in respect of health practitioners as they're defined under the Health Practitioners Act.
Any other questions?
Thanks, Annabel and Nicolette. Lots to think about. But as a retired teacher, I'm sorry, I don't feel any more confident after your talk because I think teachers might be in a bit of a different position from counsellors and therapists in that we interact with these students every day, not just at scheduled appointments. And when we're working in a school where a child says they've changed sex and they've changed their pronouns and that's the school policy, how can, I just don't see how a teacher can avoid being forced to follow a policy that they disagree with and even perhaps teach concepts they disagree with. So I feel like teachers are just really caught in a trap here.
Yeah, I mean, it's cold comfort for people in that situation, because the solutions that the courts would offer are months and years away from the teacher saying, well, not everybody holds that belief, my beliefs are different, or challenging a child or a policy in any way. The courts will uphold your right to have gender critical beliefs, but that's not much help in the playground. I think it comes back to what the other speakers today have said, and I haven't heard all of them, but if you keep talking and there are more people that you're aware support your view, it's going to become easier to be braver. And of all the problems that might appear to be before you for being brave, this act is not one of them.
Okay.
I just want to thank you both, Annabel and Nicolette. I'm a psychotherapist, and for us and counsellors, what you've said is reassuring. So it's good to hear. Thank you.
Okay, any questions? I guess we've come to the end of the day. It's been a full day, and thank you to all of you, to all the speakers, and to all of you who were online and here present for the richness of the day. Thank you.